Good morning. Thanks for taking a little bit of time. Obviously, we're in unprecedented times. Our industry has not ever been through anything like what we're going through right now. COVID-19 has changed everything, and the new normal, unfortunately, is likely to last into 2021, if not longer. In fact, I would say we really have to be prepared that things are never going to go back to what they once were in this industry. And most of you on the webinar have been able to survive thus far by using your PPP loans and other means to provide some level of assistance to get you through the first part of this period. The longer term picture is a lot tougher. And as those loans become due and the funds run out, many of you are going to be faced with some very tough choices to move forward. Bryce is going to take you, Bryce Woodyard, who's CEO of FTR Hospitality, he's going to take you through a little bit of update on PPP and what's changed. And then really the bulk of what we're going to talk about is Joseph Pack, who is an attorney who has very deep expertise in financial restructurings, and he's going to take us through some of the options that you might consider to get through, what is the new normal. Most exciting is an option that most of us had not ever heard of before, even though our firm FTR works with restaurant groups on restructuring and trying to become more efficient and really the whole back office side of things. We hadn't really heard much about this before. Joe educated us on it recently, but it's an option that is called Chapter 5, and it's a very easy, less costly way to restructure your finances through bankruptcy, but not with all the costs and the complications and the time-consuming process that a Chapter 11 or a Chapter 7 would require. So after Joe completes his presentation, we'll have time to take questions. So if something pops in your mind and you want to put a question up as we're going along here, we'll do that. And then we're going to really try to have time for a pretty robust discussion and get you the information you need. So I'm going to start by turning it over to Bryce, who's just going to give you a brief update on PPP.
Yeah, and right now, a lot of you are probably worried about filling out the forgiveness applications. The good thing is you've got 8 months from when you file to fill out the applications. And what we're telling people is, unless you're positive you can get 100% forgiveness, it's kind of a wait and see approach. The most recent stimulus bill that was, argued over in Congress had some additional forgiveness provisions in it that would be very helpful. So we're kind of saying wait until that comes through, and then the forgiveness side will be hopefully easier. There's talk of up to $250,000 per loan would be automatically forgiven. So for many of you that would be hitting the easy button as opposed to filling out the application, providing your payroll registers, doing all of that. And then the good news is, whenever Congress can get together again on another stimulus bill, it looks like the PPP is a part of that, a new PPP. About a month ago, there was pretty serious talks, and then when the executive order came out, it kind of put a damper on it. But it looks like whenever they resume again, that we will see a second round. The current requirements on it are a little more stringent than the original PPP. It's 300 employees max. You have to be able to demonstrate, at least in the month of April or May, a 50% revenue decrease. And that is really it. So if you can demonstrate that, there's possibility for another round of PPP coming through. But right now, it appears it's at least 2 weeks off, but we'll see.
Okay. Well, thanks, Bryce. I want to get into, Joe's got a presentation and a bunch of slides he's going to take us through that really give you a nice look at all the different options that are out there if you need to restructure. So I'll just turn it over to Joe, who's head of PAC Law.
Thanks a lot, Bryce and Rick. Good morning. Nice to sort of see you all. My name is Joe Pack. I founded PAC Law about 3 months ago at this point. I've been practicing in complex Chapter 11 restructurings for over a decade. And I've worked on, the most complex, hotly litigious restructurings in the world, and wanted to, when Subchapter 5 was enacted, to jump out of that environment and work on the street, as they say, and become a street lawyer so that I could actually help the community and the smaller businesses that can take advantage of this new Subchapter 5 process that Congress put in place. I wanted to just, we'll get to it as quickly and expeditiously as possible today, because I'm sure many of you have a general understanding, at least from top line, the top line on what Chapter 7 and Chapter 11 provides. But I think that, we'll quickly go through those so that you can appreciate the nuances of why Subchapter 5 is so incredible. So as you can see on the slides in front of you, we'll talk about some negotiation strategies that you have, because something that I think a lot of people don't understand is that bankruptcy lawyers try to keep people out of bankruptcy. I hope they do. I do. I think I view bankruptcy as either A, a last resort, or B, a strategic tool. I don't think that a bankruptcy should ever be a situation where someone's kind of raising the white flag. And with that, let's just get to it. Oh, I do have to say this. I always forget that I'm not your lawyer, and that the presentation today is just for informational purposes only, and nothing that we discussed today and nothing in this presentation should be construed to create a legal arrangement between us, and there's nothing today that would be considered privileged and confidential. So, a lot of restaurant owners have been calling me and asking me what they should be doing now, what they could be doing now that are facing an uphill battle in terms of their finances. And the first thing that's incredibly important, to the extent that someone hasn't done so, and I think that Rick and Bryce can really, what they do can really help with this, is in terms of getting your finances in order and understanding exactly what you're looking at in terms of a snapshot of what you have today in terms of obligations and assets, but really what your ongoing liabilities are in terms of the day-to-day operational expenses. And a lot of my clients are actually very surprised at how small those could be when push really comes to shove in terms of wages, rent, utilities, taxes, and insurance. Because sometimes, there's too much insurance and it's not necessary. And, there are sometimes employees who are on the payroll that are just because a restaurant owner doesn't want to have a really difficult discussion. But the fact is that, you can't bring the whole boat down because you have too many people hanging onto the anchor. This is insolvency. This is restructuring. It's in a business owner's duty, their fiduciary duty, to be minimizing these expenses. So don't forget that, and always have that in mind. And one of the other things that's also incredibly important is that banks want to be hearing from you. So I represent banks and lenders and landlords as well, and they're not taking kindly to the borrower or the tenant or the that hasn't been in communication with them. So pretending that nothing's going wrong and kind of trying to, quote, stay under the radar isn't really working, because the banks aren't stupid, and they know that everyone is struggling and everyone is having an issue. So to finish that off, it's not a bad idea it doesn't have to be incredibly beautiful and a work of art, but I think that it is very important to have a balance sheet together, financial projections, and a budget for going forward. So I'll go through this slide really quickly, but one of the things that's really important to understand is the difference between your secured and unsecured debts. And that, secured debts are those like equipment loans where your lender actually has a lien in your collateral, where if you don't pay, they have the right to repossess. Some loans are not like that. So your general unsecured loans aren't those type of loans. And as you know, if you don't pay those types of loans, they turn into lawsuits, and then the lawsuit will turn into a judgment if not paid, and then that plaintiff will have to figure out how to collect on that judgment, as opposed to a secured loan where there's an agreement in the security agreement and the loan document itself that if you don't pay, they could just come in and repossess. And so one of the things about bankruptcy that's incredibly important is the automatic stay that goes into place on day one of the case that prevents creditors from doing that and giving an opportunity for a breathing spell to work out a deal with the creditors. So I have a quick slide here that I know that a lot of tenants are really interested in terms of negotiating with your landlord and how to do that. And I think that the easiest way to kind of spell this out is really just what are your leverage points and what are the landlord leverage points. So you have importantly to understand is that if you were to file potentially for any type of insolvency proceeding, by law, a landlord's claim is capped at 1 year's rent, or technically the greater of 1 year's rent, or 15% of amounts due for the rest of the lease. But just most of the 99% of the time, it's 1 year's rent. That threat of bankruptcy and the fact that they'd have a general unsecured claim that's capped at 1 year's rent is a potent threat if it's made genuinely and sincerely, but not necessarily adversarially to try and get a deal going. Foreclosure moratoriums, I mean, those are starting to lift in many jurisdictions. That's a big problem for borrowers and for tenants. Force majeure clause in your lease. If your lease provides that, a pandemic or a government order allows you to not have to perform, then that's another thing that is a tool in your tool chest to negotiate with your landlord. In fact, there was a bankruptcy case that's been cited in the last 2 months, that's been cited by almost every restaurant borrower in bankruptcy, where a bankruptcy court actually said, even though your lease is a state law issue and bankruptcy court is federal law, and we've looked to state law, in the meantime, while you're figuring that out, because you're only doing delivery and takeout, and you're only using 25% of your restaurant, we are going to rewrite your liability and rewrite this agreement and say that for now, you only owe 25% of your rent. So, there are a lot of very restaurant borrower tenant friendly holdings that are coming out of bankruptcy courts that are recognizing that there's not a lot of choices. And then finally, it's not really easy for a landlord to find another restaurant to come in this environment to take over and pay rent that they're getting now. On the other hand, landlord leverage is that if they have letters of credit or escrow deposits, those are arguably not protected in a bankruptcy filing by the company. There's the opportunity for eviction, and then if there's valid guarantees, the personal guarantee on a debt is not always. It can be in certain circumstances, but most of the time, a guarantee is not discharged, a personal guarantee, by a business bankruptcy. They're separate. So we don't have to spend a lot of time on this slide because I think that we're going to want to really have an interactive Q&A session today. But the point is that the beauty of a formal federal process and a formal bankruptcy process is that the moment you go into bankruptcy, something called the automatic stay kicks in, which is effectively, it blocks all creditor action, attempts, phone calls, mailings, everything to collect on a debt. So as soon as a creditor or lender takes any action, whether it's direct or indirect, to try to collect money, even if it's placing a lien, that's an indirect way to try to collect money. It's illegal under federal law, and either that party itself or the attorney who they hire to do it could be subject to monetary sanctions. They call that the breathing spell. So I'm skipping over chapter 7. I'm going to talk about it now for 3 minutes. And then I want to talk about chapter 11 for a couple minutes, because then I want you to understand really what's different about those two, and we'll talk more about subchapter 5. But in a chapter 7 proceeding, everyone has a general idea that this is a liquidation. This is truly raising the white flag. You just walk away from the business, you give up, and a Chapter 7 trustee is appointed by the government, and they come in to basically sell your assets in piecemeal. So the way that I always analogize this for clients is, look, if you have a car and you just think that there's no way to keep this car running, then you file for Chapter 7, and the Chapter 7 trustee is going to come in and part it out. They're going to sell your tires, they're going to sell your airbags, your steering wheel, the whole thing. And so the issue though is that how does a chapter, let's talk about the reality of a Chapter 7, and what people don't appreciate is that a Chapter 7 trustee makes money from two ways. They get one way technically, but through two avenues. So the one way that a trustee makes money in a Chapter 7 is that they get a percentage of what they distribute and the money that they're able to distribute to creditors. So if you have $100,000 sitting in a bank account and they're able to use that to distribute to creditors, they'll get a percentage. On the other hand, another way that and so understand that they can only effectively make that percentage one of two ways. They're selling assets, right? Easy. Or two, they're filing lawsuits and getting judgments and collecting on those judgments. And this is the thing I should emphasize, that a lot of borrowers who file for Chapter 7 liquidation don't appreciate, is that it's not a clean break most of the time. There's look back periods on all the transactions that have been, had by the company, where the main question and focus by the trustee is what assets or cash left the company prior to the filing, and what assets or cash came in. So the fact, and those are called constructive fraudulent transfers. It gets very complicated, where you don't even have to be intending to defraud anyone. But the point is that if money's going out and a requisite asset isn't coming in, and what's a perfect example of that would be a dividend to a stockholder, right? Or a dividend to an LLC member. If there's a dividend going out and cash is going out of the company, and that cash is not available for creditor recovery, then what came into the company on account of it? So it's the whole point of that is that Chapter 7 is not clean, and a lot of times in most cases the settlement has to be worked out. Then you go to the other extreme of bankruptcy, and a Chapter 11 proceeding, let's call it, is like the Rolls Royce of bankruptcy. I also want to say at this point right now that there's really not a lot of stigma to filing a corporate bankruptcy. A lot of people have a lot of strong feelings on this. They run the gamut, but I just want to throw this out as a data point for a second. In 2009, at the bottom of the corporate economy, there were 36 or 39 bankruptcies by companies worth over $1 billion. In 2020, since May, there have been 46 bankruptcies filed by companies with over a billion of assets and $1 billion of debt. So I just want to put that in perspective so that you understand, and that everyone understands, that corporate bankruptcy is used as a strategy and it's used as a tool. But just because, and the reality is I asked this question and people finally agree, is are you going to stop shopping for a clothing brand or at a certain grocery store because you read somewhere somehow that they maybe went through a Chapter 11 proceeding? The answer is mostly no. So it's not different for a small business. And the point of a Chapter 11 is to completely restructure the company's debts, to just management stays in place. And what you're effectively doing is you're right-sizing your capital structure. So if you have, for example, a company that has $500,000 of debt, but only has $200,000 of debt, we'll put forward a plan, but can only handle $200,000 of debt. We'll put forward a plan where the company on the other side has $200,000 of debt. And then the question is, what can creditors recover in the case? Now, here's the big problem with Chapter 11. And I will tell you, I'm not getting into details at all because I want to really slowly walk through subchapter 5, but there's two legal aspects of Chapter 11 that don't exist in subchapter 5 that are incredibly important. One is what people refer to as the absolute priority rule, and it actually is exactly what it sounds like, where creditors have absolute priority over equity holders and over debt. So if you're going through a waterfall, number one is your secured lender, because, the secured lender has a lien in collateral. So think about your equipment lender. If you borrow money for your equipment and you can't pay, the loan on the equipment, that lender can come in and take that equipment. So if you're not in a restructuring giving that equipment back, you still have to pay that secured lender to keep the equipment. So that's absolute priority number one. Absolute priority number two are just other general, other creditors. And that's why they say debt is better than equity, because then number two are your other creditors. And then number three, and at the bottom of the food chain in terms of distributions, is your equity. So the absolute priority rule basically provides that so long as your creditors aren't getting 100 cents on the dollar in recovery, equity can't keep anything. So the owners lose the business. So take Brooks Brothers, and here's a fun fact. Simon Mall, right? Simon Mall is a lender or a landlord that has gigantic claims in these cases, and many of them are actually secured, either secured claims where they have a security interest on all of the assets inside of the stores or inside of the restaurants that are in their malls, or the stores that are in those locations cannot carry on without that location, and they need Simon Mall to somehow come to an agreement. So what's going on right now, and if you Google Simon Mall's bankruptcies restructuring, you'll see all of the headlines where Simon Mall is actually taking a piece of the reorganized company and actually investing through forgiveness of their debt in the bankruptcy. By now on the other side, they're going to be potentially part owners of Brooks Brothers, for example. So the reason why I say that is because the problem with Chapter 11 is the absolute priority rule, where equity is out. So forget about the fact that it's incredibly expensive. We'll talk about that, when I talk about subchapter 5 in just a minute here. But that is, you lose your business in an 11 unless you buy it back at fair market value from yourself in an 11. That's not a feasible plan 99% of all cases. The second aspect that's really important that applies in both Chapter 11 and subchapter 5, which is the little brother to Chapter 11, is something called the best interest tests. And in order for the plan, which is effectively a contract with all of your creditors on how they're going to get paid and how the company is going to move forward and move out of bankruptcy, is that there has to be a showing to the bankruptcy court that whatever is being put forward by the company as a plan, the creditors are doing better, it's in their best interests, AKA they're doing better under this plan than they would be doing in a Chapter 7 liquidation. That's normally a very easy threshold to meet, because most of the time in a Chapter 7 liquidation, all of the money is just going to go to the Chapter 7 trustees' fees to pay the Chapter 7 trustees professionals, and there'll be little, if anything, left for creditors. So if a plan is put forward that gets creditors anything, it'll typically satisfy that test. So then we have now, and this slide covers the process of Chapter 11, and we can come back to it. But I really do just want to get to brand new subchapter 5 of the Bankruptcy Code. So here's what effectively happened. Congress last year, through the Small Business Reorganization Act in August to take effect in February of this year, basically said, look, we get it. We have a real issue with our cities. And the real issue with the cities is that Chapter 11 can't just be available for huge companies, because the fact of the matter is there's no way for small businesses to reorganize. One, they can't afford the expensive attorneys that know how to navigate Chapter 11. Two, they can't afford the process otherwise. And three, management can't, in these small businesses, don't have the time to run these small businesses and watch the bankruptcy proceeding at the same time. That's also, it's setting up the company for failure as well. So there was really, for a company that couldn't afford it, not a restructuring avenue, and liquidation was really typically the only option. So Congress comes out with the Small Business Reorganization Act. It takes effect fortuitously in February, where for any company or restaurant or bar, anyone, any business that has less than 2.275 million of debt can go through a subchapter 5 plan. Now, fast forward to March, and we've got the CARES Act, and Congress said, whoa, this is going to be a real game changer, and we need to expand this, and we're going to expand it to any entity that has less than $7.5 million of debt. And this is what they effectively said. So they're like, look, We're not going to have, the committees. So for example, you're in a chapter 11, there's a committee of creditors that's formed that has to hire a lawyer to make sure that the debtor or the borrower in bankruptcy is doing everything correctly. Guess who has to pay for that? The bankrupt company actually has to pay the lawyer for the creditors in a chapter 11 by statute. However, subchapter 5, Congress said this is crazy. There's not going to be an unsecured creditors committee, and there's not going to be a trustee that is put in place to attack any of the transactions. The trustee, the subchapter 5 trustee, is only going to be put in place to monitor the case and make sure that the debtor is doing everything they're supposed to be doing. So the point is subchapter 5 comes in and they eliminated the most critical part of chapter 11, which is the absolute priority rule. And so creditors in a subchapter 5 do not have to get paid in full in order for the owner of the business to keep the business. So I want to say that again because it is so critically important for everyone to understand, is that in a subchapter 5, you put the company through bankruptcy, you reorganize, the company stays in business, it continues running, everything stays as it is in the ordinary course. And all you do is shed the debt you don't want to. You tell the bankruptcy court, look, here's the deal. We will pay, and this is the requirement, the discretionary or extra income of the company that would normally go to our owners as dividends, separate than salaries, okay? This is not salaries. What would normally go to our owners as dividends, as extra discretionary profit, we will put together a 3 to 5 year payment plan, and we will pay the creditors the best we can with respect to that debt that we have before the case. So the point is that you don't have to pay creditors in full, and all you have to show is best interests, in that the creditors are doing better than they would be in a 7 liquidation, because Congress said, look, it's fine. Here are the 2 benefits from a policy standpoint. We don't have a vacant storefront on the corner where there was a beautiful restaurant, or a beautiful, let's call it a beautiful Italian pizzeria. It's now not a vacant spot. And creditors, whether they like it or not, they're still doing better than they would be if the store closed. So we have a double-sided benefit here. The business continues. That's good for the local economy, and the creditors that are owed money are doing better than they would if the business closed. So here are the benefits. Like in 11, the debtor stays in control, and I'm reading from the slide now. Unlike in 11, there's no unsecured creditors committee. There's no absolute priority rule. There's no disclosure statement. That's a document that goes out for the voting to get votes from the creditors, which is another huge issue. So here's the other incredible part that's also really important of subchapter 5, is in a chapter 11, you need at least one class of creditors that's not getting 100 cents on the dollar in recovery to vote in favor of your plan. In a subchapter 5, you don't even need to send out your plan for a vote. You just submit a plan with projections to the bankruptcy court in good faith under the penalty of perjury, and you're saying this is the best we could do. Here are our projections, here's our financial statements, this is all we think that we're going to be able to pay to our creditors. And that's it. It doesn't matter if the creditors are happy or not. So the other thing is just, the burdens are here below, is that you do have to put those financials and the projections together. You do have to qualify by having less than $7.5 million of debt. And because it's a fast track, cheap bankruptcy, relatively speaking, unlike a chapter 11 where you have 1.5 years to file that plan and those projections, you only have 90 days to do it in a subchapter 5. So those, and here's my contact information. It's the end of the presentation in terms of the top line, top level parts of subchapter 5. But we didn't want, Bryce and Rick and I really just didn't want this to be a 1-hour webinar where we lost the audience through, getting into the weeds. But we wanted everyone to know, and we think that it's incredibly important that restaurant owners know that they don't have to give up their name, they don't have to give up their IP, they don't have to, they don't have to give up all of those special trade secrets that you've worked so hard for in a liquidation. If there's somehow, some way you can make some payment with the ongoing business, even if it's only 10% or 20% of what it was pre-COVID. So Bryce, Rick, unless you think that there's any more details that I should be getting into, I'm happy to turn it back over to you.
Well, it sounds like it's a much more simple way to go through the process, a fast way, but it's also, it's an option that a lot of people aren't thinking about.
Yeah, right. And I'll tell you that my colleagues that work at large law firms in the country don't even know what it is. And a lot of, distressed debt investors that work in Manhattan that are dealing with companies and retailers that have a lot of debt don't even know about subchapter 5, because it really is truly for, the quote small businesses. But it is so perfect for restaurants and bars that it's something that every restaurant owner and bar owner really does need to know about.
Yeah, I think that everybody is, there's a lot of stigma around the word bankruptcy, right? But really, this is times you might have established a great business and things were going along pretty well. But again, this has been a devastating time for everybody, and it may not come back for a long, long time, if ever, to be normal the way it once was. So this is in a sense, I think a subchapter 5 is a reset switch. It's a chance for you to, without disrupting further your day-to-day operations, to really make sure that you have that foundation to go forward. And I think it's something people should seriously take a look at. Bryce, you want to add anything on that? I know you're talking to people all the time. No, I can't hear you. You're maybe muted.
Yep, muted. Sorry about that. Yeah, so I think it's something to consider, because I think a lot of restaurant groups, maybe your sales are just now finally rebounding to where you have positive cash flow, but the debts you may have accumulated over the last 3 to 4 months, make it so that you can't continue to operate your business. But this is, like, as you said, Rick, a reset to kind of right size your business, get it so you can wait this thing out, because it looks like as we get a vaccine or whatnot and things improve, that you can expect sales to start coming back up. But you've got to be able to get over that hump. So
I think another point to consider is the fact that right now an awful lot of people, most people from what I've heard, are not paying regular rents or not paying rent at all. Now, there's been a lot of protections. Orlando had a moratorium on it. Other parts of the country, other municipalities have had a moratorium on evictions and et cetera. But that's all coming to a close pretty quickly. A lot of those moratoriums are, those things are running out. We're starting to see landlords start to file actions against tenants. So, I urge you to not just wait to see how much forgiveness you get off your PPP loan, but also take a look at, get out and ahead of this a little bit, and you might find yourself in a much better spot, down the road. And with that, do we have, I don't have any written questions on the board. I don't know, Ashley can tell me if we can take audio questions or if we has to be written. I'm not certain.
They do have to be written, so if anyone has any questions, they can submit those to the questions pane, or contact you guys after the webinar.
Okay.
Well, I just want to add one point about subchapter 5. That's a question that I do get a lot in terms of right sizing the debt and stigma, is that most customers are not even going to know about the filing. That's number one. There's no reason for them to. You're still just operating in the ordinary course. And the second thing is regarding the payment plan, your debts are what you can pay. So for example, if you have $1 million of debt, but you can only pay $200 a month for 3 years, then the debt becomes $2,400 over 3 years, and that is the debt, and then it's discharged. It's gone. It's not like a payment plan to repay the debt you have and come up with a payment plan. It is truly a write down of the debt.
So a question did come in. So what circumstances do you think where you would recommend filing, a subchapter 5? And I know that's a general question, but is there a threshold of, debt to equity, cash flow, or, what would make you definitely recommend a chapter 5, subchapter 5?
It's a fair question, even though it's very, very general. But to give a general answer, I would say if the company is losing cash on a monthly basis on its balance sheet, and the runway of that cash loss has an end in sight. So if you can only carry on for 3 more months or 4 more months at that rate, it's time to really think about filing the subchapter 5 and going through that and going through that process. Because the fact of the matter is that you also need some time to put together your financials and really figure out what you do and don't need on a go forward basis in the business. You also need some time to take a look at the agreements to see if you have personal guarantees on those agreements. But I mean, that's the first way I would answer that is how long can you survive based on how you're operating now, number one. And then number two is if you had your debts that you didn't need on a go forward basis, right size down to just something that you could offer those creditors to pay them. And the answer to that is yes, that you could survive if, for example, you didn't have to pay a bunch of vendors that aren't going to be providing goods and services for you in the future, and you don't need to enter into contracts or assume contracts with them. You're ripe to think about this process very seriously before you get down to that point where you're out of cash, you can't pay for a professional, you can't pay creditors anything, and a trustee will just come into your business and guess what? The trustee will ask why you didn't do this. Because a lot of things that owners and members with fiduciary duties to their investors and their creditors don't realize is once you hit a point where you can't, quote, pay your debts as they come due for the foreseeable future, which is a year, is the standard for what to look at, you're operating in what they call the zone of insolvency. And then every single one of your decisions that you make financially while you're in the zone of insolvency is going to get questioned by a trustee or whoever comes in down the road that says, well, how come in August when you had $400,000 or $250,000 in your bank account and you were losing $50,000 a month and you could have put a plan in place that would, that could have rendered a creditor getting 10 or 15 cents on the dollar in a bankruptcy reorganization? Why did you make the business decision, and were you informed, and did you, what duty of care or duty of loyalty were you exercising when you just continued the business to make sure that it had absolutely no money left? And those are the types of questions you just don't want to be having to answer in a liquidation.
Mm-hmm. Another question is with a subchapter 5 filing, does that deal with, is a PPP loan forgiven?
Yeah.
How is that going to work?
Yeah, so I get that question all the time. And the answer to that is yes. If you had your PPP loan and you've received the funding prior to the filing, there's no reason why a bankruptcy filing, as per the guidelines as they are now, that doesn't mean they can't change, but in terms of where the guidelines are now, the bankruptcy proceeding is one thing, and the criteria for PPP loan forgiveness is another.
Another question is, out of the various filings, chapter 7, chapter 11, and subchapter 5. So the question is essentially what type of situation would work best for each of those, or who would be most benefited by those different scenarios. And I think that, if I might, I think that one of the simple answer is, I think what we're saying on this webinar is that small businesses, the subchapter 5 is just an unbelievable option compared to the others. But I know that, Joe and I have worked through a bunch of major restaurant chapter 11s over the years. And it is a brutal process that really often serves to just further drain whatever whatever cash or funds are left in the entity that's going through the restructuring. But I'll let Joe answer that.
I mean, look, that's absolutely right, and the reason why is because what a lot of people don't appreciate and business owners appreciate in a Chapter 11 is that you've got to be going out and sending a plan of reorganization to your creditor groups. You've got to get their votes by majority, in 51% by number, 67% by dollar value of their claims, and you've got to be going and getting their yes votes on your plan and getting support on your restructuring. In addition to that, you've got to draft and circulate to all of those creditors a document called a disclosure statement that explains to the creditors in painstaking detail what the transactions were of the company on a look back of at least the past 6 years, in terms of describing why they're getting the distribution they're getting, why they're getting, why certain settlements with certain creditors were cut. All of that has to get explained in a document. That's a record of evidence and of the court, and the cost to put those documents together just doesn't make sense for a company that only has $500,000 or $1 million of assets. And so the point of subchapter 5 is to just short circuit all of that and just be like, look, we understand that maybe Chapter 7 would be the only option for you, but again, I make the point that Chapter 7 it's not a clean breakup. I mean, you're still going to be having to deal with the trustee. You're still going to be having to turn over all of your financial records, your bank statements, your credit card statements, even potentially your personal information, to the extent that money was being transferred out of the business to your personal account so the trustee could track it and potentially claw it back. It's not clean. And the point of subchapter 5 is it is, because what you're doing is, by giving your creditors a promise that you can pay them what you can pay them, and they're definitely doing better than they would be in a Chapter 7 liquidation. The incremental cost of the professional to run that process, which, by the way, if you get deposed or sued by a Chapter 7 trustee, you're probably going to want to be hiring a lawyer anyway to defend you in those suits. So the fact is that if you have the incremental cost of a professional to get you through a subchapter 5 process, it could end up being cheaper, both for the process and in terms of what you have to pay out to creditors.
So on the quick follow-up question on the PPP loan forgiveness with the subchapter 5, what about an EIDL loan?
That's a great question. So that is a very good question, and there is no guidance on that at the moment. I've been getting that question a lot, and the fact is that's something that will have to get worked through with the agency.
Okay, another question. What if you're in the insolvency zone and regarding rent payments, but you have personal guarantees on those leases? What happens in a subchapter 5 in that case?
Okay, so that's another great question. That's a question I get all the time. So a subchapter 5 proceeding any bankruptcy proceeding by the business, unless there are certain circumstances, and I don't want to get too detailed, because I want to keep this high level. There are certain circumstances where personal guarantees can be discharged through a bankruptcy proceeding of the company. However, it's rare, and it's typically in very sophisticated corporate situations where there's indemnification obligations between the company and the guarantor. There's insurance involved. It's an involved factual question. It's not impossible, and it does occur. Unfortunately, absent some type of deal with the landlord, you'll be on the hook for the personal guarantee.
So do you see those being restructured typically,
yes,
or being versus forgiven?
Yes. So you can buy out a forgiveness. And so I'll tell you, I had a client 2 months ago that they had a personal guarantee on a lease. They restructured the lease, and they took a small discount on the lease. They continued paying on the lease, and then they paid a lump sum to buy out of the personal guarantee. It was a $25,000 payment to the landlord to get out of the personal guarantee. The reason why that was money very well spent was because the fact is that if they down the road wanted to put the company through an insolvency proceeding, there would be no personal liability whatsoever forever with respect to the claims on that rent. So that's a very important fact, because if that claim increases down the road based on the way the contract's written and the damages can increase, it's a calculation that has to get looked at, given that there are certain base rents that increase with inflation, or that there's certain minimum revenue requirements, and there's make wholes, having to make the landlord whole for not coming up with that revenue. That personal guarantee could be more expensive down the line and could actually trigger, sadly, a personal bankruptcy.
Okay, that's all the written questions we have. Are there anybody else have any written questions? Send them in now. Otherwise, I think we're going to wrap it up. Any closing thoughts, Joe, on why small restaurant owners, and let's face it, a lot of the small restaurant group owners in Florida and independents do have personal guarantees against their homes, et cetera. Any final thoughts on subchapter 5 or this topic?
Well, so that's a really great point that you just raised. And the fact is that if there are certain debts that you have for your business where there's a lien on your home, those can actually get restructured through a subchapter 5 as well, because the policy in Florida of protecting the homestead is actually much more important to the state than the policy of paying business creditors. So I don't want to get into the details too much on that, but I want everyone to understand that if you have liens on your house and there are certain percentages of what those liens against your house are with respect to business debts, and it can be traced that the money lent against the house was actually used for the betterment of the business, those loans can actually be restructured in subchapter 5 as well.
All right, I'll ask a final question. So if somebody's interested in this, Joe, what should they do? Obviously you're an expert in this and they could contact you, but how else, what would you suggest?
I really think, I don't want to say, oh, just call me. But that's really where it needs to start. I think that to keep a consultation simple and very informative, the first thing that I would be doing is getting all of your financials in order. How much do you owe? What's personally guaranteed? What's not personally guaranteed? What relationships and creditors do you need going forward to keep your business alive? So, for example, and I'll say this as an example. If you don't need to use UPS and you can use FedEx instead, and you owe money to UPS's claim becomes a general unsecured claim. Maybe you could use them going forward, but you don't have to pay them for pre-petition agreements or pre-bankruptcy debt. Or if they don't want to work with you anymore, then fine, you just use FedEx and you don't use UPS. But for example, if you're a pizza restaurant and you absolutely need the vendor that provides your pizza crust because your business survives on how fantastic your pizza crust is, that's a creditor that you can, that you're going to want to think about how you're going to treat them in the bankruptcy, if you're not just going to make them whole and assume the agreement, whether it's an oral agreement or a written agreement going forward. So, those are the things that you have to understand, kind of have a good idea before you seek counsel. And I think that, bankruptcy counsel is the first place you should go, understanding that just because you get a consultation or talk through issues, it doesn't mean you have to file. I have, for example, a client right now where I'm literally just negotiating with all of the creditors a payoff to discharge the debt and enter into a settlement agreement with 15 creditors. So there's going to be 15 signatures on the settlement agreement, and the company is not going to have to go into bankruptcy at all. That's understand that it's not a fait accompli just because you call a bankruptcy lawyer and ask some questions. And then, what Bryce and Rick do is in supplementing that and complementing that skill is, they can really help in terms of the financial side of things, and to really, work with you on how to right size in terms of the non pure legal aspects of it. But they too have a really good idea of some of the legal weapons as well, and on the main concepts.
Okay, great. So I think that's it. No more questions, and really appreciate. Great job, Joe. Bryce, thank you. And I guess that's it for now.
Thank you for the time, and for those of you that paid attention, I appreciate it. And I do hope that this is a really good avenue for you in case you need it.
Great. Well, thanks very much. And this will, I guess, conclude the webinar. Thank you.
Thank you.